Hello, I'm Christopher Burgon. I own and run Christopher Burgon Solicitors. We are a specialist litigation and commercial law firm based in London. We help business owners win disputes. This video is one of a series for business owners, directors and shareholders. They've decided they want to separate from their current fellow directors and shareholders. Now we've got a 7-step process. This is number 5 in that process, and this is about valuation of the company. Now, valuation of the company is the reason for a lot of disputes between shareholders. If we look back over the process that we've been going through, we've decided that the company is being properly run, even though we've decided to split. Control of the company is with the person who's actually preserving the assets and the value within the company. That might be you. Hopefully you've agreed to do that between yourselves anyway. Number 3, you've had a basic look at where the value of the company lies, and you've also dealt with the effect of misbehavior, breaches of duties, and the effect that that has had on valuations. After you've done that, step 4 was to decide who is going to buy who out of the business. And now you are ready to instruct a valuer. Valuation of the business is often at the heart of a lot of shareholder disputes. And if you're ahead of the game, you will have entered into a shareholder agreement which will have set out how the valuation of a share or a shareholder in a situation like this is to be determined. If you have, then great. You have to follow the shareholders agreement and that will solve a lot of problems. If not, then you're going to have to start from scratch. Hopefully though, as we suggested previously, your view of the general value of the company will help. So what you need is a specialist valuation expert. Very tempting to go to the company's accountant. Resist that temptation. He'll be happy to take the money from you. He's probably got lots of ideas about the value of the business, but it's often not very helpful. In disputes like this, often one party trusts the accountant and the other doesn't. The accountant may well have a conflict of interest. Don't forget the accountant is also engaged by the company, where in a shareholder dispute, this is you personally against another shareholder. So resist the temptation to go to the company accountant because they may not be qualified to give a kind of useful valuation that you need, and there may be a conflict of interest, and any distrust between you and your fellow director shareholders may be magnified by using the accountant. So who should you use? As I say, you should use a specialist valuation expert, and ideally one who has experience of giving evidence in court and includes within their experience acting as an expert witness. Why do you need somebody who can act as an expert witness if you're not going to court? Well, it's because you want a valuation of the company which take into account all of the matters that have arisen between you and your business partner, which is likely to include some kind of breach of duty, breach of obligation. And that may lead to a court case, but right now what we want to do is get the valuation so that we don't have to go to court. Your instructions to the expert are crucial. You should try and agree the scope of those instructions with your fellow directors and shareholders. And as I say, crucially, they should include the effect upon the value of the company of any breaches of duty, breaches of obligation, such as taking money that they shouldn't have out of the company, or even trading against the company, or misusing the IP, or various other matters. If you can agree the valuation, then fine. If you can agree the instructions, the terms of the instructions of your valuation expert, that is a great step forward. You can choose to jointly instruct one expert, or you can each instruct your own. The plus side of instructing one expert is it's just one set of fees which you'd share. The downside is if that expert gives you a valuation which you don't like, then you're kind of stuck with it. If you each instruct an expert, it's likely that they'll come up with some kind of divergence of opinion, some differing opinion, but then the experts themselves can speak together to work out what they think a reasonable value is. How to value a company is an art, not a science. There are various different ways of doing it. It can be based on the assets of a company. More likely, it can be based on the multiple earnings of the company or multiples of earnings over the years. So for example, we'll look at the earnings in a company for the last 3 to 4 years, and we'll then extrapolate forward what the earnings are likely to be in the next 3 to 5 years. There are different ways of valuing a company. The two big ones, a commercial valuation and a fair valuation. And I say fair with a capital F and in inverted commas. A commercial valuation is what it says it is. If someone wants to buy your shares, a third party, they're going to go to a valuer, get a valuation of your company, and then they will pay that amount for your shares. That's a commercial transaction, you're being bought out. In a situation like this though, where you and your business partners, your fellow directors are separating, you are more likely to want a fair valuation. And I use the word fair because if one of you should issue an unfair prejudice petition, which asks the court to order a sale of shares, the court will look at a valuation which it considers to be fair. And that will be based on the commercial value of the company, but it will also include elements such as misconduct by one of the parties. And so the court will decide what, in all the circumstances of the case, including the commercial value of the firm, is a fair value for your shares. So that's why you would want to instruct a valuer to come up with a fair value rather than a commercial value. The other area that always rears its head is a minority shareholders discount. If you're selling 30% of the shares of a company, for example, the value of those shares is very rarely considered to be 30% of the value of the full company. That's because if you buy a minority shareholding, you don't really have control over the business, so there's a discount given for that. That also goes up to even a 50% share of the business, because if you buy 50% shares of the business, then you still can't control it, so there's a discount for that. There are certain situations where companies are referred to as quasi-partnerships. That is where the directors and shareholders are the same people. Then courts are reluctant to apply a minority discount to a valuation of shares in those circumstances. In the circumstances where, in a quasi-partnership, one of those director shareholders has been excluded from the business and they are seeking an order for sale of their shares from the court. In all other cases though, a minority discount will apply. Hopefully that's been of help. We're very nearly there. The company's been stabilised, the right people are in control of the business, you've had a rough idea of the value of the shares, you've decided who's going to buy out who, and now you have your expert valuation. You're very near the end of that process of separating from your fellow director shareholders without going to court, so please keep watching for numbers 6 and 7. If you would like to speak to me about any of the issues in this video or our other videos, please contact us. Please go to the website, click on the book a meeting button. That will take you directly to my calendar and you can speak to me directly for 30 minutes. Alternatively, drop us an email or give us a call. We'd love to hear from you. If you would like to leave a comment or have a question about the content of this video, then please do so underneath. Thanks very much.